Good morning. This is the 7th meeting of the Bills Committee on Private Columbaria Bill. We've got a quorum already, right? I'll introduce the officials to you after they've come in, but I believe you know them very well, so maybe I don't need to introduce them to you again. Concerning the submission from the Consumer Council and its paper CB2910/01, the administration has provided a response already. I don't think we should discuss the content of the reply now. When we reach the relevant clause in the clause-by-clause scrutiny, we can have a discussion on the relevant part of the reply. So, long title, Clause 1 bracket 1, Clause 1 bracket 2, Part 4 Division 1. In other words, clauses 10 to 12, we've completed the scrutiny, and now we will start with clause 13, Division 2, Subdivision 1, Blue Bill C3421 of the English version. I think we'll start from there today. Eligibility based on legal compliance, blah blah blah. Thank you. Just to briefly recap, last time we were on C3387. And some members raised the following point, and that is some provisions come into operation on the day the ordinance is passed, and some come into operation on the expiry of 3 months, beginning on the day on which the ordinance is published in the Gazette. And so, in fact, we're talking about subclause 3A, B, C. And now we will deal with Division 2, eligibility criteria. Subdivision 1, application for licenses. Subdivision 2, application for exemption. And then third, application for the certificate. And so we'll now deal with eligibility criteria for the application of a license. And then clause 14, as members are aware, having regard to the existing situation, we need to deal with the eligibility criteria for pre-bill Columbaria. So first of all, application for a license. We're talking about leases, tenancies, and also a management plan. 13.1. The applicant has to satisfy the licensing board that it can fulfill certain requirements, or else the application may be rejected or refused. So these are the criteria. 1A, land-related requirements have to be met. Second, planning-related requirements have to be met. And then third, building-related requirements have to be met. And the detailed requirements can be found in the Schedule 2. And then the applicant has to prove to the satisfaction of the licensing board that the applicant holds the columbarium premises directly from the government, whether under a lease, license, or otherwise. Then clause 13, subclause 2. The applicant has to submit a management plan. For example, crowd control arrangements during the peak periods. And the management plan has to be found acceptable by the licensing board. Clause 14. There are already pre-built columbaria. And for these columbaria, modifications may be required. So if there is an application, Section 13 will be suitably modified. And members can refer to subclause 1ABC. So at 8 a.m. on the 14th of June, when the bill was published, or announced, the ash interment layout is limited in extent to that as at the bill announcement time. And then second, the ash interment capacity is limited to that as at the bill announcement time. And C, that the extent of occupation of land as is necessary for or ancillary to the operation of the columbarium is limited to that as was necessary for or ancillary to its operation as at the bill announcement time. Then bracket 2. The licensing board may decide not to review or may decide not to refuse the application even if the pre-built columbaria do not comply with the building-related requirements if the non-compliant structures necessary for or ancillary to the operation of the columbarium are structures certifiable for a pre-built columbarium. And B, the requirements applicable to the structures specified in Section 4.3 of Schedule 2 are complied with. Subclause 3. The acquired premises. In fact, we hope that the premises are owned by the applicant. But for pre-built Bill Columbaria, then the licensing board may decide not to refuse the application even if the applicant does not hold the Columbarium premises directly from the government. Whether under a lease, license or otherwise, if the licensing board feels that it would have granted the application but for that section and the applicant proves to the satisfaction of the board that the applicant has the right to continue to use the Columbarium premises for at least 5 years, beginning on the date on which the license, if issued, is to take effect. So I'll pause here, Chairman. Yes, Mr. Wuchiwai, 7 minutes for each member, including replies. Thank you, Chairman. I want to clarify one point on this clause. There are premises for the interment of ash, and many of these premises or organizations have already been registered, but some of these premises are in multi-story buildings, and I think this is the major concern. Can I seek clarification in relation to clause 14? Is it that in future the licensing board will no longer consider applications in relation to premises not on the ground floor of buildings? And if the answer is yes, then what is going to happen to existing premises which have already been registered? How many such Columbaria are there existing? All right, I think I will invite the PAS to answer these two questions first. Yes, thank you, Chairman. We will explain the requirements in detail to members when we come to Schedule 2. And in reply to Mr. Wu's question, I wish to say that there are different types of buildings in Hong Kong. There are small houses in the NT, and there are also multi-story buildings in the urban area as well as in the NT. Concerning premises on the ground floor and on the upper floors, we have to look at these in the right context.
In the new territories, there may be some that are multi-storied buildings, and we can't say that these could not be included because according to CAP 123, according to the Buildings Ordinance, they have already received approval or consent for that purpose. And if it actually is applied to this purpose, then we are not saying that we refuse to let them do it. But later when we move on, then we would explain clearly that there are many requirements for that. And in future, we would also come up with guidelines. At least there would be 2 flights of stairs. We would also mention the loading, because we need to calculate the loading. And they might not really comply with all these regulations. There are some cases in multi-story buildings, some could continue with these operations, but some cannot. Chairman, I think you need to look at these 2 paragraphs together. Well, which part are you referring to? You said you need to look into 2 bracket 3. Well, in under 13 1A 1 2 3, there's actually a very clear clarification in Schedule 2. If we can go into Schedule 2, you would understand very clearly. How about we move on to 3? Let's move on to Schedule 2. C3587, the English version, and C3586, the Chinese version. Well, just now we talked about some of the exclusion, and here you would see mention the compliance with land-related requirements, planning-related requirements, and building-related requirements. So if you refer to 3C3587 for the English, 3C3586 for the Chinese, and you would see under general provisions, it talks about what is called land-related requirements. The Columbaria must comply with the land-related requirements only if A. The operation of the columbarium does not involve unlawful occupation of unleased land. So you should not be using or taking up government land. And B. The lease, license, or other instrument under which the land on which the columbarium is situated is held from the government is complied with. So you must comply with those conditions. So you only comply with the land-related requirements if you comply with these. If you comply with 1A and B, and you would ensure that there would be follow-up to make sure that you comply with the land-related requirements. Second, compliance with planning-related requirements. The threshold is also very high. The columbarium must comply with the planning-related requirements only if the columbarium complies with every requirement under the Town Planning Ordinance Cap 131. So 13 and 14, including the pre-built columbarium, if you want to apply for the issue of a license, then you must comply with every requirement under the Town Planning Ordinance as well. Chair, I think we understand that these are very strict regulations, but not sure ever the government has done any assessment. Let's say, what percentage of these columbariums you assume would find it difficult to comply with these requirements, especially for those in multi-story buildings, because once the bill passes, then it might be very difficult for them to continue operation. Yes, it is difficult. Let's not go into buildings. Even for planning only, you need to assess the traffic, and then it needs to be circulated by the different departments. Right now, you cannot say whether they would be successful or not in receiving the app, in being approved. Well, if they're still in the process of trying to comply with the requirements, we wouldn't know exactly, because they are still in the process of trying to comply, and it also depends on how the town planning board looks at it. So right now we don't know whether it would be successful or not. Well, Chairman, excuse me. Well, could we ask you to see how many Columbaria are involved? We want to know at least a number. Well, if these are still in process while you're issuing the license, then I want to know how long it's going to take. Principal Assistant Secretary, well, once the bill comes into effect, we are also going to move on to the waiver. We would require them to do their best to fulfill it. Well, Mr. Wu is asking whether you have such information. Have you already assessed the current issues related to land? I mean, do you have an estimated number? Mr. Wu, is that your question? Well, let's say you try to put this in a chart with the information you have right now. Well, of course, they might need to adjust to comply with the requirements, but at least, I want to know a number. Do you have the number? Let me put it this way. we have the information on which are complying, which are not, as some may still be working on the land-related requirements, some on planning-related requirements. Some of them have submitted application, yet they have not successfully complied with the requirements. We wouldn't know, whether these would be successful, even though they have already submitted the application, because they're still in the process of trying to comply with the requirements. Well, you do have such information. Yes, so can you provide us with such information? Well, 13 and 14 must be scrutinized together with Schedule 2, because inside I don't see because you see many requirements. I don't think we could just look at 13 and 14. We should look at Schedule 2 in detail, and then we would be able to understand 13 and 14. Otherwise, we'll be jumping back and forth in the bill. Mr. Wu, the government has mentioned, the issues in Schedule 2. How about we first look at Schedule 2 first to see whether members have any questions on 1 and 2 under general provisions. If not, we move on to 3. 3 is compliance with building-related requirements. A Columbaria must comply with building-related requirements, no matter what kind of application or license it's applying for. A states that if the Columbarium complies with the requirements for approval and consent to the commencement of building works under Section 14 of the Buildings Ordinance, Cap 123, and every other requirement specified by the licensing board, including requirements related to design, construction, structure, fire precautions, health, sanitation, or safety. And there may be other requirements on building works, on sanitation. So every requirement specified by the licensing board must be fulfilled. Last time, Mr. Leung asked about some of the small structures in new territories. For these small buildings under Cap 121, or they might already have a submitted application before, you cannot say that they are violating it because they have complied to certain they have complied to other requirements, and so Cap 123 would not apply to those. But of course, we must also look at the building requirements. We're using certifiable buildings to stand for these structures or buildings. Regulations are different in different eras, and so we have already listed out how we define these buildings. So what do we mean by certifiable buildings? It means that although Cap 123 does not apply, we call it a building to which the requirements for approval and consent to the commencement of building works under Section 14 of the Buildings Ordinance do not apply because it is a new territory small building that came into existence on or after October 16, 1987. Well, if the building has been renovated, or then Cap 123 will apply. But if not, then it will fall into a pre-1961 NT building requirement. And it is and if the new territory small building complied with the repealed buildings ordinance at the time of its erection, then it is also called a certifiable building. So if it's a building that is that came into being around 1961 to 1987, then this would be under category 2. On October 16, 1987, then you would need to look into the Buildings Ordinance application to the New Territories Ordinance Cap 121. Then these buildings would be in category 3. In B, which means that the buildings that came into existence on or before January 1st, 1961 and before October 16, 1987, then at that time, as long as it complied with the building heights, then it would be counted. But then after 1987, Cap 121 required a submission to the Lands Department on a certificate of exemption issued under the Buildings Ordinance. So if the certificate of exemption has been issued, then it will still be considered as a certifiable building. If that small building did not apply for the certificate of exemption, then it will fall into buildings that are in violation. So for a certifiable building, we're talking about a different set of regulations and requirements. So we would look at need to look at it through a different set of regulations. If you look at B, bracket 1, well, even though it complied with other requirements, if it's acting as a columbarium, I would also need to review it. So you would see that in B2, it talks about we need a professional to prove that it complies with safety regulations before we would consider it.
The licensing board will look at the situation and may require that certain works be carried out on the certifiable building. For example, something must be done to the loading, or an additional staircase has to be provided, and so on and so forth. So, and the building has to be certified to be structurally safe by a qualified professional, and the licensing board may impose certain conditions. C3591, subclause 4, we have a number of definitions. For example, what is meant by the new territories, anti-small building, pre-1961 anti-building, and repealed buildings ordinance. For anti-small buildings, we make reference to the definitions and the criteria in Cap 121. All right, so let's pause here and see if members have got any questions. Mr. Wuchiwai, thank you. It merely says here compliance with the provisions in the town planning ordinance. I just want to know what are the provisions in the ordinance and the terms in the DMC are similar. Yes, PAS. Chairman. Clause Section 2. The Town Planning Ordinance. I want to say that it is different from the DMC. The DMC is a contract applicable to the owners. According to Cap 131, we need to look at the OEZP. For example, we have to look at whether the use is an approved use under column 1. And then if it's a column 2 use, then planning approval has to be obtained. Or if it's a pre-existing use before the publication of the OEZP, then the certification has to be obtained from the planning authority. I think Christine can say more about the planning ordinance, and I can supplement with regard to DMCs. Ms. Chair. Now, what is meant by compliance with the town planning ordinance? Now, first, is an existing use. In other words, it's an existing use before the OEZP is published. Second, it has to be an always permitted use. We have to look at whether columbarium use is a column 1 use. In other words, an always permitted use for that zoning on the OEZP. And then third, if the use is a column 2 use on the OEZP, then it's a use that requires prior planning approval. And if an application is made to the Town Planning Board and approval is given by the board, then that would also be regarded as compliance with the Town Planning Ordinance. Thank you, Assistant Director. I think we all know DMCs very well. Do you really wish to have a reply? I just want to know the relationship between the DMC and the Town Planning Ordinance. What if there are uses disallowed in the DMCs? For example, in the case of commercial residential buildings, the Town Planning Ordinance is kept 131, and it imposes restrictions on land use. Then DMCs, they bind all the owners. Last time we explained clause 17 to members in relation to public interest. For existing Columbaria, we've checked if they are covered by DMCs. In fact, in Part A of the Development Bureau's list, there are none. In multi-story buildings, in Part B, there are 28. And then out of the 28, there are 20 with or 20 such buildings of DMCs. DMCs contain very complicated legal provisions and conditions. So we have to have lawyers to look at whether these are permitted or not. Of course, there are difficulties. And if there are gray areas, they have to be looked at very carefully from the legal point of view. And we haven't got any categorical views, but I think Mr. Wu is asking you this question, and that is, what if the use is prohibited under the DMC? Because it says under Section 2 that there must be full compliance with the Town Planning Ordinance Cap 131. But then what if the use is disallowed in the DMC? And will you, because of this, refuse to grant the application? Because, Chairman, the board can take into account public interest. Say, if the residents point out that the use is in violation of the DMC, then the licensing board would definitely take that into account. But then violation of the DMC alone may not mean that the application will have to be rejected. Sometimes the case may have to go to the court. Now, it's like the situation concerning guest houses. It's a commercial activity, but then it may be housed in a residential building or a commercial residential building. Just want to say that there may be conflicts. Now, for the guest houses, the situation is even worse because in fact, the law says that guest houses should be in residential instead of commercial buildings. So I think we should make use of this present opportunity to clarify one policy issue, and that is whether such uses should be allowed in, say, residential buildings or commercial residential buildings. Mr. Albert Chen, are we on clauses 14 to 16? Yes, but then we've gone to Schedule 2 because we think it's better to deal with Schedule 2 first and then go back to clauses 14, 15, and 16. So we're now on page C3587 of the English version, Schedule 2. Yes, Mr. Albert Chan. I think this is one of the most complicated and difficult bills before us, Chairman. Now, because we're talking about very complicated rights, ownership rights, management rights, and all these rights and obligations are intertwined. I think an ownership-based approach should be adopted because buying a niche place is like buying a parking space or even a flat. But of course, these niches are the so-called flats for the deceased and not flats for those who are alive. I think we need to really have a complete change of the concept or the mindset. In some overseas countries, niches or the ownership rights of niches are sold, and burial places in cemeteries are also sold as if they were flats. And I think this is a more appropriate approach. And then, Chairman, concerning Schedule 2, I've got this suggestion. Now we are dealing with this bill, and then this bill will also deal with exemptions for pre-bill Columbaria, and at the same time we have got applications going to the town planning board for the construction of new Columbaria blocks. So is it really, or can the government consider imposing a freeze on the new applications for Columbaria blocks? This bill seeks to lay down a framework. But this legal framework has yet to be put in place. The licensing regime has yet to be worked out. Things are still uncertain, and I'm worried that there will still be a lot of uncertainties pending the passage of the bill. So I think the board should no longer receive new applications for Columbaria blocks pending the passage of the bill. In fact, we did spend a lot of time discussing policy issues and matters of principle. But then we are now on clause-by-clause scrutiny, and I don't think we should start a protracted discussion on the principles and on the policies. So maybe the government can give a brief reply. But I think Mr. Chen is correct. This is a very complicated bill covering both macro issues as well as minute details, and we have to deal with the past, the present, and also the future. So I think we really have to continue clause-by-clause scrutiny, and we should not digress to start another discussion on the policy aspect. PAS, yes, Chairman, I can understand the members' concern, but at the moment we do not have the powers under the law, and so we do have some difficulties.
At the town planning board, you must consider the application within the period of time, which is 2 months here. If it's under 12A application, then the application must be considered within 3 months. So this is actually a regulation under the town planning ordinance. Well, I have a simple question. Well, I understand the ordinance, but then the town planning board secretariat will not be able to refuse the application. But maybe if you could try to reduce some of the work burden on the town planning board secretariat, that would be better, because right now it is not very realistic in considering applications, because we're not talking about over 1,000 niches in application. I think you need to look into your different procedures. The different departments should take into consideration this. I'm sure that I've already heard your views. Thank you. Mr. Lee, Chak-yen. Well, yes, I think you would only look at this with a view on public interest. Well, of course, this sounds good, but then if it is already a done deal, then the public would be very mad, and they would say, oh, you will need to go through judicial procedures, and it would become very, very complicated. I want to see how you look at public interest. Have you considered a consultation period to allow members of the public to give views and not just to make this into a done deal? Well, that's my first question. Second question is related to Schedule 2, in which there's a mention of certifiable building. Well, it's actually in violation, but it could be called a certifiable building. It seems that the regulations are very relaxed. So, for these non-compliant structures, do you just try to describe it as a certifiable building? I want to know your ideas, because if I just look at these non-compliant structures, as long as professionals are able to say that this building is safe, then it would be considered a certifiable building. Thank you, Mr. Lee, for your comments. Last time after you expressed your ideas, we have gone back to take a look. Let me refer to the first question. First, we would put up the notice on the application online so that members of the public who are affected could express their concerns. We also used as reference on the regulations on small motels. For the certifiable building, this actually should be under Section 4. Well, there are some very strict clauses here. Well, I would clarify all the details when we move into Section 4. Thank you. So this is under Section 4 in Part 2, all right? Mr. Leung, please. Thank you. I want to have a better understanding of the certifiable building, because there are only a few descriptions of what is defined as certifiable. I'm concerned with these buildings in the rural areas because it is quite difficult to identify sort of certifiable buildings. Last year, I remember seeing a building that was built in the 80s. But it's a few stories high, more than 3 stories high, and not the regular houses or regular sized houses you see. So I think there were a lot of extensions made to the house, illegal extensions made. But then since it was built in the 80s, then it would not be considered. Let's say it's a 4-story building. Well, there have been many complaints in this rural area because this building wanted to be a columbarium. But then the town planning board declined the application. This building is still in place. It still wants to become a columbarium. So I'm just concerned, Chairman, that once the bill is passed, the residents there would really object to it. Well, but now, under your certifiable building description, then it's now considered a certifiable building. Or even if members of the public object to it, it will still be used as a columbarium. I want to understand whether this, or I think the Lands Department has already suspended the land lease, but then if the town planning board approves it and gives it the green light, then it could still become a columbarium. So I want to know how you treat this kind of certifiable building. Well, I think if you've been rejected before, then I don't think you would really be considered under this section. Well, I don't think they would be able to be approved because there are a lot of thresholds. Well, we started to identify what is meant by a small building, because if you look at CAP 121, it cannot be larger than 700 feet in area and not more than 3 stories high. If it's already over 3 stories, it's 4 stories high, then it's already not considered. And we need to look at which year the building was erected. It still needs to be looked at by a professional to ensure that it is a safe building, and you might not be able to prove that. And the licensing board might also ask them to comply with certain conditions. So, there are many thresholds that you need to overcome. Now, how about, the villagers opposing to this idea? Would that also be be put under consideration? Well, yes, we would put up a notice so that those living around the area could express their views to the licensing board. And of course, these would be taken under consideration before approval is made. Thank you. Mr. Wu Chi-wai. Thank you, Chairman. I see in Section 3, the term certifiable building is used. In Schedule 2, there is a special provision for pre-built Columbaria and their requirements applicable to structures certifiable for a pre-built columbarium. It seems that the wording is very detailed for Part 2. I want you to confirm that when we talk about new application for licenses, it would also need to comply with the requirements or the special provisions for pre-built columbarium, that it would also be along the similar guidelines. Well, we first look at whether those structures are compliant or non-compliant. If they are compliant structures, then we would look at what kind of exemptions they're looking for. Even if they are compliant structures, and we still need professionals to ensure that it is safe, and there would be additional conditions. But if the structure is non-compliant, well, when we move on to Section 4, you would see that we have very, very strict guidelines. Even if you're able to pass the first threshold, you would still need to prove that it's a safe structure and it's a certifiable structure. So we impose a very, very strict regulations, and you would see that there is this difference. Well, why would I ask this question? If you look at Section 4, you look at the B description, which said it said that they form the whole or a part of the ground story of a multi-story building, but do not form the whole or any part of any other story of the building. This description, well, to my understanding, yes, you can, we could work around the ground story, but not the stories above the ground floor. Well, if I put this concept into the concept of certifiable building, I don't see any related clauses that state the same idea, or we would see many cases that the ground story of a building still is used commercially, and the above stories are for residential use. If you look at B under section 4, it seems to tell me that you cannot use the stories above the ground level for residential usage. Well, you've moved on to section 4 already, Mr. Wu. How about you ask those questions when we're already in section 4? How about we first move on to section 4 because we haven't yet moved on to section 4, because I'm afraid the other members would not be able to follow because we are scrutinizing this bill. I don't want to jump around to different sections now. I understand what you mean, but I think we should wait until we move on to section 4. Ms. Wong, how about you move on to C3590? Because members are very concerned with the section with the conditions right now. Okay, let us move on to part 2 on special provisions for pre-bill Columbaria. Or if they're not pre-bill Columbaria, then you don't have to consider these special provisions. Well, we have to accept history, of course, because some Columbaria existed pre-bill. If there are any non-compliant structures, then how do we deal with it? Before we go into the requirements, we first set out the definition under 4.1, a definition of non-compliant structures, which mean any building or building works that do not meet the conditions in section 3 bracket 1 of this schedule. These do not meet the conditions in section 3 bracket 1, then they would be considered as non-compliant structures.
And for non-compliant structures, they will be looked at very, very carefully by the licensing board. So, these non-compliant structures must exist before the bill announcement time. And they contain niches used or intended to be used for the interment of ashes, where at least a niche in the structures was so used immediately before the bill announcement time. And then they form the whole or a part of any essential ancillary facilities supporting the operation of the columbarium. Now, say for example, if there is a furnace, it must be one which is ancillary to the operation of the columbarium. Then B, we're trying to have the scope ring-fenced. Now say if there is a wall Say it may be an on-grade outdoor structure with niches. Then they form the whole or a part of a single-story building. If it's a multi-story building, we only allow the columbarium to be on the ground story. Then fourth, say after 1987, if no application has been made to the lands department, then that would be non-compliant. So these are those which have not been covered by certificates of exemption. And then 2, because it says any building, and steps have been taken to try to fulfill the requirements laid down by the lands department, but then we still need certification by a qualified professional. And then B, say if there are non-compliant structures, like the interment of ashes on the rooftop, then of course that will come under B. Then 3, a qualified professional has to certify that the premises are structurally safe, and then some rectification works may need to be carried out. Then 4, the definition for a ground story. Mr. Wu Shuai? Thank you. B3. I think it basically says that only premises on the ground floor will be regarded as suitable. It's said here that an application has to be made to the building authority. But then the buildings authority does not look at the use itself, say outer walls or non-compliant uses in the premises. The buildings authority only looks at the safety aspect. But then the use inside the premises may be in violation of the DMC. And so is it that the building authority's approval is not equivalent to a consent or an approval to vary the terms in the DMC? So I think you should under B3 list that that will not be approved. PAS, a prior application is needed. We can't make an application afterwards. Even for religious buildings, we do require applications to be made afterwards. Mr. Yu. Chairman, Section 4 deals with non-compliant structures. Mr. Wu wants to know whether they are compliant or non-compliant structures. Mr. Wu, in fact, that's not my question, because under 3, it says that of course government land must not be occupied, and then second we're talking about planning permission, OZP, and then number 3 concerning the buildings, and we look at cap 1, 2, 3. Now, if an application is made to the building authority, it's merely a technical or an application which is technical in nature. But then the building authority doesn't look at whether the use will be objected to by the residents in the building. As Mr. Lee Chuk-yan has said, in this case, people may have to go to court. And then it is said that here that only the ground story will be accepted. I think we can imagine that there are only shop spaces on the ground story. But cap 1, 2, 3 doesn't look at this. Cap 1, 2, 3 only looks at the building aspect. Now, say for example, if you apply to the building authority for approval for subdivided units, the building authority doesn't look at whether the use is allowed. Now, of course, we have here talking about the ground story, but then for 3, prior approval has been obtained under section 14 of cap 1, 2, 3. So in other words, Columbaria on upper floors may also be allowed. But if, say, there is only one staircase, then approval may not be granted. Part 2 is restricted to the ground story. And the DMC is an other area. And we'll have to seek the advice of the HAB. I'm getting more and more confused. Schedule 2 is about licensing conditions. Then if I want to apply for a license to the licensing board, I have to fulfill 1, 2, 3. And then now section 4, retrospective applications. For example, you will not deal with things outside 4B. So we have this set of licensing conditions. So is it that I can still apply to the building authority so that I can satisfy the requirements? But then 4 is about pre-built Columbaria. And you're asking why they can't spell out very clearly that only premises on the ground story may be accepted, and premises on upper floors will not be accepted. Now, if one owns the entire small building or small house, yes, then doesn't matter. But then it says quite clearly here the ground story only. So I think this is in relation to multi-story buildings. Pre-built Columbaria. Some of them are existing in multi-story buildings. Please look at 3(1)(a). You have to get approval under Section 14 of the CAP 123. That's the first limb. And then there are other conditions that may be laid down by the licensing board. For example, 2 staircases and additional loading. Under Section 4, we're talking about cases which haven't been granted approval under Section 14 of CAP 123. Yes, I understand. Perhaps I'll put my question in another way. No, I bought a 6th-floor flat in an old building, and I want to operate a Columbaria, and then I carry out building works. Then under CAP 123, can approval be granted? Now, Section 14 of the Buildings Ordinance says that prior approval from the building authority has to be obtained before works commence. In other words, if there is a building with occupation permits issued, then the requirements are met. Say if I buy a flat and I alter the partitioning, I may change the location of the main door. So either an application has been made to the Buildings Authority, or I can carry out the works under minor works. And then next, the licensing board will look at the design of the premises, the layout, the safety requirements, and so on and so forth. So the member seems to be saying that a license will be granted if the conditions under 3.1a are satisfied. I want to say that these are all the requirements as far as building safety is concerned. The licensing board may impose conditions on fire safety, hygiene, structural safety, say for example, how many staircases, the loading, and other aspects. So the licensing board may impose additional conditions.
So do I take it to mean that under 3.1a, if it's a new application, new building, then basically you wouldn't be able to be approved? Well, it would be difficult because you would need to go through the many different departments. If you're talking about residential buildings in the urban area, the town planning board might not necessarily approve it too. So if you need to comply with all the requirements, all 3 of them, then it would be very difficult for sure. So let's say I want to operate a columbarium in a building. It will be considered as commercial use, right? So you would need to approve for the planning use, right? Well, let's say if that is a building that is in a residential area, then if you want to be approved, then it would be very difficult. Well, columbarium is not a kind of commercial use. It's for use for columbarium. It's not under resident. It would not be under residential use. Thank you. Let us move on then. We could move on to Schedule 2. We've already explained Section 4. Now we can move on to Schedule 2, Part 3 on interpretative provisions. Section 5, that defines the meaning of small building. It cannot be more than 3 stories. Each height cannot be more than 7.62 meters. With 7.62 meters, but not more than 8.23 meters, and the thickness of the walls, etc. But don't worry about that, because if you are familiar with the small building under Cap 121, then basically the meanings would be the same, and you would understand the kind of technical requirements referred here. Next, in section 7, meaning of undefined word or phrase. You can a word or phrase not defined in this part has a meaning given by section 2 of the Buildings Ordinance, Cap 123, or section 2 of the Buildings Ordinance, application to the New Territories Ordinance, Cap 121, for small buildings. So small buildings need to meet many descriptions in height, in the thickness of walls, etc. Mr. Leung Chi Chung, do you have any questions regarding these details? All right. If not, we're finished scrutinizing Schedule 2. Let us move back to clause 13 and 14. Any questions? Or if not, let us move on to clause 15. So now we move on to clause 15 on page C3425. Here we talks about the exemption for pre-built columbarium, the eligibility based on datedness, legal compliance, and premises held from government or right to occupation. If the applicant fails to prove to the satisfaction of the licensing board one or more of the following from A to H, then the licensing board may refuse an application for the issue of an exemption. Since it's now applying for the issue of an exemption, A, the ash intimate layout is limited in extent to that as at the bill announcement time. B, the ash intimate quantity is limited to that as at the bill announcement time. C, that the extent of occupation of land as it is necessary for, or the ancillary to, the operation of the columbarium is limited to that as was necessary for, or ancillary to, its operation as at the bill announcement time. D, that the columbarium commenced operation before January 1st of 1990. E, that no interment right in respect of the columbarium has been sold since the bill announcement time. Otherwise, it would lose its eligibility in application. F, the columbarium complies with the land-related requirements we've already explained in Schedule 2 that you could not use government land and must comply with the other requirements as stated. G, the ownership rights Oh, sorry, it's on the building related rights. For G, it should either the columbarium should comply with the building related requirements. If there are any non-compliant structures, then they will need to comply with the conditions set out under Schedule 2. H. Sorry. Oh, we have 2 new members have just arrived. We're now looking at C3425 regarding Clause 15 of the bill. Next, we can continue now. H. So G is related to the land-related requirements that must comply with the building-related requirements. If not, then there should be requirements applicable to the structures scheduled in Section 4.3 of Schedule 2 are compliant with. H1. The applicant holds the columbarium premises directly from the government, whether under lease, license, or otherwise. Or if the licensing board is of the opinion that it would have granted the application, but for subparagraph bracket 1, the applicant has the right to continue to use the columbarium premises for at least 5 years, beginning on the date on which the exemption if issued is to take effect. Then for 2, then for Clause 15.2, for the purposes of subsection 1D, the operation of a columbarium commenced on the order of the following. The first time when a set of ashes was interred in a niche in the columbarium, or when an interment right in respect of a niche in the columbarium was sold. Okay, so you would take the earlier date, right? Yes. Mr. James Toh. Well, for some places in the new territories, I think you will need to rent at least for 5 years. Well, some places, actually are rented from the government. Sometimes the government would only lease it out for a short term for 2 years. If it's a short-term lease, I think you will be able to see it from C3. Then you would look at Clause 7. That it should be concurrent with a short-term lease. Well, of course, you must need to apply it through the Lands Department on short-term lease, and we need to understand that this is owned only via a short-term lease, and so it cannot exceed the period of the short-term lease. Yes. Well, I'm just giving an example here. Well, maybe the ash interment place would be owned by the operator, but then the car park, the bathroom facilities are rented from the government. Well, does it mean that the ash interment place, as long as it is self-owned, then you will be able to issue an application? Or how would you consider it? Well, we're talking about exemptions, and of course we need to look at the 2 different tiers. We have to look at the operator and the consumer. Does the operator own only a short-term lease if it's regulated by a short-term lease? No, that's not the question. How can a consumer buy such a ownership? No, that's not the question. The main hall for the ashes is self-owned, but there are ancillary facilities around it, so as to convenient the consumers. Oh, I understand. So then you would have to be the period of time would be dealt with, because we would consider it under self-owned premises. Well, in case of dispute, let's say two brothers are fighting for ownership. The younger brother seems to be the owner, but the older brother is fighting for inheritance with him and said the piece of land belongs to the older brother. So the older brother has already sent you letters, asking you, not to approve the application. And there are many such cases like this, on inheritance disputes. Well, so before a judgment was made, would you still give out a license or not? Well, I think you need to look at the facts and circumstances, because the responsibility lies with the applicant. The applicant must prove to the satisfaction of the licensing board that it owns the land. Well, yes, there is proof, but somebody is in dispute saying that the piece of land does not belong to him, but the judge has not yet ruled that the piece of land belongs to the older brother. You have to look at it as different scenarios, because if you say that it is to the satisfaction of the licensing board, how about when the case is is under judicial proceedings? Because there are many complicated cases, as you know. So you'll have to be very clear. If you say that, well, in case of dispute, there would be a pending decision, then then you might be clear. You have to first look at the consequences for these different scenarios. Well, I understand your question, that during this process or this process of application, there is still it's still under judicial review. Then I think we would have to give you a written reply later on, because we need to seek legal advice. How about we provide this information later on?
All
right. Any further questions? Then we can move on to 16. Yes, C3427. Chairman. Now, so a license is applied for when a columbarium is operated and the ashes are interred there. Say someone has got a license in the mainland, and then if I want to wish my ancestor, I have to give notification 3 days in advance, and then the operator will arrange for the ashes to be transported to Hong Kong. Now, I think we have to think of all possible scenarios, because land is very expensive in Hong Kong. I know that many law firms do store their documents outside Hong Kong. And then say the ashes will only stay in Hong Kong for 5 hours, and then they will be transported out of Hong Kong again. So what will happen in that scenario? Please refer to clause 2 for the definition of ashes. And then may I refer to page 3391. Premises keeping or intended for keeping ashes. So yes, undertakers and also domestic premises or homes are exempted, but others will be caught. So in other words, approval has to be obtained. So you can't just transport the ashes to Hong Kong and keep them in the premises on a temporary basis. But no, people will only meet the ashes there. The premises are not meant for keeping the ashes. So I have some doubts as to whether that amounts to keeping the keeping of the ashes. Is that regarded as a temporary Columbaria? Now, is that does that really or is that really tantamount to keeping of ashes? Because as you know, land in Hong Kong is extremely precious and expensive. Say if I give notice 2 days in advance, and then the operator will transport the ashes to a place with a very strong religious atmosphere. For example, is that the same as keeping of ashes? Now, if I can think of such an arrangement, clever businessmen can, of course, think of such arrangements. So it depends on whether Hong Kong people are willing to accept such a mode of operation. And some Hong Kong people may find the arrangement acceptable, and it's going to be so much cheaper. So this may be a good idea to many people. Stupid as I am, I can think of such a scenario. We're not talking about virtual worshipping of ancestors. I think we need to consider whether we really want to allow this to happen. In other words, the transient keeping of ashes in the premises. It depends on whether the public are willing to accept this arrangement. But then the problem is that this mode of operation may cause a lot of nuisance to nearby residents during the 2 peak periods in the year for ancestral worship. I think the member wants to know whether keeping covers such an arrangement, and this is an issue that we have to look at. Now, say for example, I don't want to place the ashes at home, and I will ask someone to take the ashes to the mainland, and then when I give notice to that person, the person DHL the ashes back, and then he will take me together in his car, and we both go to a religious institution, and we carry out ancestral worship. And prohibit me from doing that. Now, of course, for ancestral worship at home without affecting others, should we exercise any control? But then at the same time, let's look at worshipping at religious institutions. And if there are many people doing the same thing at the same time, then there may be a lot of nuisance caused to the residents. Maybe the applicant can come up with a sound traffic management plan that can satisfy the licensing board. But then if you ask me, I think I would say that we are inclined to control such activities. And then concerning whether the word keeping also catch activities that the member has mentioned and described, I think we'll have to look at the matter with the DOJ. So yes, I think the administration can consider the matter. Next, C3427, clause 16. Ms. Sitho, I have to apologize because I haven't been following this bill and the discussion very, very closely. But then we have the term ash interment layout on page C3429. Is there a definition for ash interment layout in the bill? Yes, please refer to C3413, clause 10, ash interment layout. It means the location of the dishes and also the serial numbering of the niches. And if a license is applied for, then we need to have the details concerning ashes kept on a temporary basis. As we're talking about serial numbering here, we are in fact talking about the keeping of ashes on a large scale. And perhaps you can look at Mr. James Toe's question against this background or in this context. All right. C3427, clause 16, temporary suspension of liability for pre-bill columbarium, the eligibility. 16.1 says that the applicant has to apply for a license as well as a certificate for TSOL. So both have to be submitted to the licensing board at the same time. Then 16.2. If the applicant fails to prove to the satisfaction of the licensing board one or more of the conditions under 1 to 4, then the licensing board may refuse the application for TSOL. The conditions are as follows. The ash interment layout is limited in extent to that as at the bill announcement time. 2, if the applicant also applies for the issue of a license, then the ash interment capacity is limited to that as at the bill announcement time. And then 3, if the applicant also applies for the issue of an exemption in respect of the columbarium, then the ash interment quantity is limited to that as at the bill announcement time. And then 4, that the extent of occupation of land as is necessary for or ancillary to the operation of the columbarium is limited to that as was necessary for or ancillary to its operation as at the bill announcement time. Then B, if there is unlawful occupation of unleased land, and no application for regularization has been made to the Director of Lands, and there is no written declaration to the Director that the applicant has no claim to the unleased land, then the board will not deal with the application. But then if the applicant has made the claim or made a written declaration and later claims the right to own the land, then will go to court. Then there is a certification, or there needs to be a certification by a qualified professional that in terms of building safety, there is no obvious or imminent danger. And so we need to make sure that if government land is occupied, an application for regularization has to be made to the Director of Lands, and then there must be certification that there is no obvious or imminent danger in terms of building safety and fire safety. We do require the applicant to make an application or to make all necessary applications to the Planning Department and to the Lands Department as early as possible. Alright, we are now on page C 3427 of the English version, clause 16.
Here you mentioned that under 16.1, the two or any of the applicants, so you only need one, right? You don't need to satisfy both, right? Yes, you just need to satisfy one. If you can either apply for issue of a license or apply for an issue of an exemption. In B, I think it's 16.2b, you mentioned if you want to apply, then you would first need to provide a written declaration that you have no claim to the unleased land. Well, in B2, it's actually stated very clearly that you need to provide a written declaration to the Director of Lands that the applicant has no claim to the unleased land, whether based on possession of the unleased land before, on, or after the date of application, or on any other ground. So there must be a written declaration based on possession of the unleased land. Any questions? No? If not, let us move on to clause 17. Here it talks about the considerations relevant to determination of applications. 1. This section applies to the determination by the licensing board of an application for a specified instrument in respect of a Columbaria, and 2. The licensing board must have regard to the public interest and may have regard to any other relevant considerations. Mr. Lee Chuk-yan. Well, yes, I understand what you mean by public interest. What do you mean by any other relevant considerations? What does that mean? Well, we're very clear about public interest. What does it have to do with public interest? Well, it's actually quite a broad definition to allow the licensing board to consider anything that is related to its issuing and license. Well, what does it mean by relevant? Relevant to public interest or relevant to what? Relevant? Other relevant considerations. Well, it doesn't have to be public interest if it's called relevant considerations in English. Well, I'm not exactly objecting to the definition being broad. I always feel that there are some cases that are non-compliant structures, that go to the town planning board again and again. I would feel that you shouldn't approve such applications, but you don't. I may think that it's relevant, but the licensing board might not think that it's relevant. So could we perhaps explore this further? Chairman, when there may be many happenings that we cannot forecast, so this is how you put it down in a legal manner. So right now you can't really define what you mean by relevant considerations. We'll have to wait till it is passed before we can tell you what it means. But perhaps we could provide you with more information on what it might include. All right, because the other relevant considerations, seem too broad other than public interest. Ms. Sid Ho, yes, public interest is already quite a broad definition because you may be talking about 1,000 of ancestral worship places. If you refer to clause 13 on license eligibility, it said it may refuse an application by the licensing board. I know this is a dilemma. You want to be broad, but you also want to be able to have the discretion to handle public interest. Well, we don't know where you draw the line right now. So this is a comment, right? Well, when we are formulating the bill, we have also considered other legal literature. Because if the licensing board refuses an application, then you will have to consider all considerations. All right, let us move on to clause 18, which is under division 3, application for specified interest. Division 3 Clause 18 on form of and information required for application. An application for a specified instrument in respect of a columbarium must be made in writing to the licensing board in the specified form and in the manner determined by it, and must be accompanied by bracket 1, 2, 3 here. For an application for the issue of a license, it must be accompanied by a management plan for the licensing board's approval and second, the plans of the columbarium, and third, the information, certificates, and other documents specified in the application form or otherwise required by the licensing board. Clause 19. We move on to requirements about plans accompanying application. The plans of a columbarium that are to accompany an application for a specified interest in respect of a columbarium must comply with the requirements in this section. 2. The plans must include a site plan, layout plan, and 4 floor plans, each of which must be in the number of copies and drawn to the scale that the licensing board requires. Third, the plans must show the following particulars to be authorized or permitted by the specified interest under application. And there are the particulars are listed from A to E. A, the ash interment layout. B, for an application for the issue or renewal of a license, the ash interment capacity. C, for an application for the issue or renewal of an exemption or for the issue or extension of a temporary suspension of liability in respect of a pre-built columbarium, the ash interment quantity. D, the extent of occupation of land as is necessary for or ancillary to the operation of the columbarium. E, the structures necessary for or ancillary to the operation of the columbarium. Four, a qualified professional must certify that the current site situation of the columbarium premises conforms to the plans in all respects. Okay, no questions. 20, please. The licensing board would need to approve the plans to be endorsed. Therefore, when the licensing board is taking into consideration the application, then we will look at the requirements A and B. A, it is satisfied that the current site situation of the columbarium premises conforms to the plans in all respects, including the particulars specified in subsection 2. And B, having regard to sections 12, 13, 14, 15, and 16, the licensing board decides to grant the application and authorize or permit the particulars specified in subsection 2 as shown in the plans. And 22 states the particulars, which is listed out from A to E. A, the ash interment layout. B, for an application for the issue or renewal of a license, the ash interment capacity. C, for an application for the issue or renewal of an exemption, the ash interment quantity. D, the extent of occupation of land as is necessary for or ancillary to the operation of the columbarium. And E, the structures necessary for or ancillary to the operation of the Columbarium. Three, on approving the plans, the licensing board must endorse the approval on each plan in each set of the plans to that effect, and must return one set of the plans to the applicant and retain the remaining sets of plans. So these are mainly on the plans. Mr. Paul Jay. Well, on the particulars, on what sort of forms you need to list out, it might be put in the schedule. But this time it's listed in detail in the main provision. So what considerations do you have for putting this under the main provisions? Well, I think this topic is quite important to the public and those living around the proposed columbarium usually would oppose to the idea. Or some of them are pre-built columbarium, and so we want to be flexible in the regulations. So we want everything to be stated clearly in the plans. And this plan, or the plans of the Columbaria, are actually very important to our bill, and so we want to attach this importance and put it in the main provision. Well, yes, I understand for the pre-bill Columbaria, this I understand. But for future applications, if you make it so inflexible in the bill, then it would be very difficult for you to amend this in the future. Oh yes, if for new applications, then I don't think we need such onerous regulations, because it would reflect very clearly in the plan how it complies with all the regulations, because there might not be any kind of non-compliant structures, and you don't need to draw this out very clearly in the plans. Well, yes, because you're talking about general provisions right now. We are not yet into the necessary papers and documents. I think that if you make it too inflexible, then it will be very difficult for you to amend in the future.
This is the first time that I come across a bill that covers macro issues as well as minute details. We have these existing columbaria. We want to have them regularized. And so it is essential that we have all the detailed requirements laid down. In fact, members have also raised many questions on the details. But of course, the government should also take into account Mr. Chair's concern. But I think we won't have these problems with new columbaria. We only have this problem with the pre-existing ones. I think time's up. In fact, the end time should have been 12:45, and so I think we'll stop here. And we will start from from clause 21 next time. We don't have AOB, and we'll inform members when the next meeting will be held. Thank you.